Very important message for all you folks out there. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. Hello and welcome, everyone. I am Nipasa Pradhan on Immigration and Jobs Talk Show, and I'm very thrilled to have you join us today. But before we dive into our topic, I want to extend a warm welcome back to a very familiar face in our show. So, without further ado, please help me welcome back Attorney Chand Parvathaneni to our program on Immigration and Jobs Talk Show. Hi, Chand. How are you doing?
Hello, Nipasa. Thank you for inviting me today, and hope you're having a good day.
We are. I mean, we just didn't have about a week or two. We didn't have you. We kind of missed you. So, how's it going with you? Any update on your end?
Sure, sure. So this month was a pretty busy month for all the folks who have been looking for H1B filings. The lottery it ended last week, and starting yesterday, the results have started pouring in. So the first set of selections started pouring in yesterday afternoon, and the process is still continuing. At this point of time, we are still seeing selections being updated in the portal. And on our
Mhm.
side, we are seeing about 15% or so selections a couple of hours back, and it's slowly increasing. So more than likely by end of tomorrow, all the selections will be updated. So what we are asking all our the clients that we represent, we are asking them to go and log into their My USCIS portals. Once they log in, they should be able to go and check who has been selected. And right now, the selections are not completely announced yet, and the website slowly keeps getting updated. So at this point of time, the selections are happening, and some people already have been notified. There are more selections that are possible, and by end of tomorrow is when we will get a complete clarity on the selections, the percentage, what is the percentage, the selection rate, and so on.
Right, and talking about it, I mean, we also had an update. Well, so for out of 10 applications, we just have one that was selected. So, I mean, 500,000 applications anticipated. What do you think? What is going to happen?
Yeah, I mean, at least based on what the thousands of filings that we have done in our the registrations that we have done on our law firm side, I think
Mhm.
we are at least definitely going to see at least 300,000 to 400,000 registrations. The USCIS has not released the data yet, but we do see a lot of demand, just like prior years. The only good thing is this year USCIS has solved a big problem, the multiple registration problem. They really refined the rule.
Right.
Now we are having a beneficiary centric rule, and not only that, USCIS has announced a lot of times last year about the multiple registrations fraud. So I think that
Mhm.
awareness, I think, was a lot more this year. So we think
Mhm.
it's going to be a lot more lesser registrations than last year, but it's still going to be a lot more than what is available out there. We know that we only have 85,000 slots out there, and
Right.
that number is going to be oversubscribed by a couple of times, a couple of multiples. That being said,
Mhm.
last year we saw 800,000 registrations. Definitely, it will not reach that levels, and I think that's more because USCIS refined their policy. They did this beneficiary-centric registration. They put a lot of
Mhm.
notices out there talking about the multiple registrations fraud and how they will go after people. So I think it all, I think, at least helped refine this process. So I think out of all the years that I've seen the electronic registration process happen since 2020, this year I think was one of the times where things were very clean, and I think that's because USCIS went with this beneficiary centric process.
Right, right. And absolutely. I mean, good changes as well. And there are some more last minute changes. I mean, with address change and there's a lockbox and everything. I mean, we'll talk so much about everything under the topic today. And really, Chand, it's so good to have you back. And a big thank you to all our viewers tuning in from everywhere on Facebook, YouTube, and LinkedIn. And definitely your continued support and engagement truly makes this show possible. So, if you have any questions to the attorney directly, don't forget to drop them in the comments below. We'll be very happy to take them. And I think let's get down to business, Chand. I mean, we are here to discuss about the topic. So let's go ahead. And today's topic is uncovering H1B application insights, navigating post lottery, e filing, and strategies for non selection. So, Chand, what can folks out there expect from this episode today?
So today, I think what we want to do is we want to discuss and talk about what's going to happen next. We know the lottery is done, the selections are coming out,
Mhm.
and we want to find out what, what's going to happen next. The selections are done. What do people whose selections have happened, who got selected, the lucky few, what do they do? What are the steps they need to take? What are the next steps before they get the actual H1B approval? We're also going to talk about what about those folks who are not selected in the lottery? What kind of options they have? We want to see, do they have to take any special precautions, any special additional steps, and other options to explore if they're not selected in the lottery. So it's more about what are the next steps after the lottery. Some people will get the filings done. Some people, unfortunately, who are not selected in the lottery, they have to go with other options. And we'll discuss more in this show.
Sure. And Chand, I mean, for folks out there who have just joined us, maybe today, first time watching you here with us on Immigration and Jobs Talk Show, would you like to tell them a little bit about yourself? So, folks out there, this is Chand Parvathaneni, attorney from Dallas, Texas. And Chand, tell us a little bit more, please.
Sure. So I've been in Dallas since the last 23, 24 years. I came here in 2000.
Mhm.
So I did my bachelor's in IIT Kharagpur back in India. And then I came for my master's in 2000 to Dallas and been here ever since. And I'm practicing as a lawyer since 2011. So it's almost 13 years, 12, 13 years that I've been practicing in Dallas area. And I've been lucky enough to represent hundreds of companies in thousands of filings. I've represented multiple corporations in over 20,000 H1B filings in my career, and that gives us a lot of insight into the kind of issues that are typically raised by USCIS, that are typically questioned by USCIS, and we see the patterns. So if USCIS is coming up with a new issue, so because of the kind of volume that we do, we kind of know what kind of RFEs can be expected. And in general, H1B is a very clean program. USCIS has very specific requirements. It is a complex process, but the requirements are very clean. USCIS has a specific set of things that they typically ask. And what we do is we represent clients, we represent a lot of corporations. We help refine this process. And overall, my experience is more into employment based immigration. I rarely practice family based immigration. And our law firm out here, we are heavy into employment based immigration. And that means a lot of H1Bs, a lot of green card filings, especially the EB2 and EB3 green cards, is pretty much what we do at a law firm back here in Dallas.
Absolutely, friends, and that is Chand Parvathaneni. So let's go ahead. With the topic today, Chand, we already have folks asking questions, and I'm very happy to tell you that we will be taking them up. So, Chand, before the questions from the viewers, can you outline the key steps involved in the H1B application process after the lottery? Focusing on the electronic filing procedures as well.
Sure. So there is a major update starting from April 1st, and that is e-filing. So H1B, historically, it has always been a paper filing. So what happens is the employer is the one that does the H1B filing, not the employees. It's the employer. So employer typically gets this entire file prepared. It's a paper filing, so everything is a hard copy. They physically sign it, and it gets sent out to USCIS. That's typically how things are done. However, a major change that is happening with USCIS is they're allowing e-filing. And what that means is the filing, that entire filing process can now be done electronic. And this is similar to the green card, the PERM filings, the labor certifications. So the labor certifications already have this e-filing. So all the labor certifications happen through the e-filing. And USCIS is getting a similar process for the H1Bs. What that means is, in terms of the burden of proof, what you need to prove to get a H1, the kind of steps you need to follow, everything is still the same. And the way the process starts is the company is supposed to sponsor. So the company is supposed to file for something called a labor condition application. So the company still has to file for the labor condition application. It's an electronic filing with Department of Labor. That still needs to be done. Once that is approved, that is certified, the employer typically works with the employee, collects all the documents. You require educational documents. You require work experience documents in certain cases. You require your previous pay statements in certain cases. Passport is always mandatory. You have an offer letter, the company making an offer to the employee stating what is the salary, what is the job. the employer coming up with the job duties. So all of that is still going to be the same. Employer has to prepare a package, get all these things in order. However, instead of going back to USCIS and submitting a physical copy, we do it electronically. So things are supposed to get streamlined. The receipting process. So once you apply, once you pay the fee online, you will get a receipt quickly. So there is no more FedExing. There is no more wait for your receipts. So overall, we're going to get to a very efficient way of filing, starting from April 1st. And I think this is also going to show in terms of the timelines. USCIS, once we file the case, what's going to happen is USCIS will have to adjudicate our petition. This is what will need to happen. So the biggest step is employer preparing this package, putting it in front of USCIS. This is what will need to happen once April 1st starts. The new process, because things are streamlined, because there is no paper copy, there is no scanning and all these things involved, even USCIS, they'll become more efficient. We expect the timelines for adjudication to decrease and things get more faster with USCIS. Overall, I think it's going to show in terms of the approval rate. Things will be a lot more refined this cap season.
Absolutely, Chand, and I'm also very excited. So are the viewers because I can see the questions popping up. So I think we should take one from the viewers to say that yes, we hear you. So Hashura is asking, can you explain the concept of a dual intent visa and how it might be beneficial for individuals not selected in the lottery?
Sure. So there is this concept called single intent and dual intent in immigration. And what that means is, for example, if somebody is coming from India, they want to apply for a F1, a student visa, or a tourist visa. Those two are single intent visas. So what does single intent mean? Single intent means you are going to US for a very specific purpose. And once that purpose is over, your intent is to go back to your home country. So student F1, you have a single intent, that is to go to US to study, and once the studies are complete, you want to go back to India, for example. That is single intent. And there is this concept of dual intent. Dual intent means I come to US for a particular purpose, but if I want to become a green card holder, I'm going to pursue my options to get a green card. That green card is the second intent. And when you talk about H1s, H1 is a dual intent visa. So I can say that I can have this intent to come to US to work on H1B visa. So my intent is to work on H1B visa. I can also have this dual intent, the second intent, that I want to become a green card holder in US. There's nothing wrong. So a dual intent is permissible for H1B. A dual intent is not permissible for tourist visas and F1 visas. So that is where this concept comes into. So if somebody is coming on a F1 visa or a tourist visa, typically the green card filing, there are a lot of things you have to think before a green card filing is done because it's a single intent visa. H1B, on the other hand, it's a dual intent visa. So somebody can actually pursue the green card process right away. That is what it means. And depending on your visa classifications, you have to be cautious on what uh, visa that is to pursue your green card. So if you're not really pursuing your green card process, you don't really have to worry about single intent or dual intent concepts.
For Hashura, I hope you've got your question answered with much clarity from the attorney. So let's take another one. This one is from Facebook. This is Anita. She's asking, are all approvals released?
I think they're talking about the lottery selections. All the lottery selections are not released as of now. They started yesterday, and the system is like very slowly updating things. As of this morning, a couple of hours back, when we checked at our law firm, we were about 15%. So 15% of all the cases that we filed got selected about a couple of hours back. So we think it's going to be a long time. It's going to be at least tomorrow evening before all the selections are done. And this happens every year. They start the selection process and the website gets slowly updated because they probably have a background process, keeps slowly updating the portal. So people can still expect to see more selections, and the selections have started but they're not complete yet. And more than likely by end of tomorrow evening you will probably have all the selections finalized.
Still have some more time, so let's keep on checking the update. I mean, let's go keep checking if our status has been updated. All right. So, Chand, I mean, talking about it, what are the primary differences between individuals selected in the H1B lottery and those who are not selected?
Sure. So the main thing is if somebody is selected in the lottery and
Mhm.
the employer, if they go to the portal, they will see the status as selected, and they will see a PDF a document, a notice, which basically says they have been selected and they can file the H1B within a certain timeline. For those that are not selected, what typically happens is the status will still say it's in submitted status. So submitted status means they're not yet selected in the lottery. They could get selected if there is a second lottery, but right now they're not selected yet. So the main thing is you have to look for that selected status in the portal, and if somebody is selected, they're good to go ahead and start their next step, which is the actual H1B petition filing. This can start from April 1st. The deadline is June 30th. So before June 30th, their employer must finish the filing of the H1B if somebody is selected in the lottery. If somebody is not selected in the lottery, we just have to wait and see if there would be a second lottery. Last year we had a second lottery. The year before that, we did not have a second lottery.
Right. So, I mean, there are so many chances because there was multiple selection process last year. So let's keep our fingers crossed and let's hope for the best, folks. You know, just stay hopeful, stay optimistic. I think that's all I can say right now. So, Chand, also I have more questions. So, could you provide insights into the effective strategies for handling the request for evidence, the RFEs, responses in the H1B application process?
So, step number one that will start after April 1st is the employers actually filing the petition with USCIS. More than likely, because we have e filing, most of the employers, we are expecting them to use e filing. In our law firm, we are recommending e filing, we are doing the e filing route.
Yes.
Once the filing is done, once the fee is paid, what happens next is USCIS takes a couple of months to review the petitions. So in a few
Hmm.
weeks, few months, what USCIS typically does is they do two things. One, they approve the case. Two, they come back and say we are not able to approve the case because we need a few more documents. And this is called a request for evidence. So request for evidence is provide us more evidence to prove your case. That is pretty much what USCIS is saying. And USCIS typically gives 87 days to answer the RFE. So if an employer files a H1B for their employee, they don't get an approval, they get an RFE. So RFE is basically saying provide us more documents. The RFE will clearly state the deadline. It will also clearly state the kind of documents USCIS requires. And getting an RFE does not mean anything like the case is getting denied or anything. RFE is a very a common thing. A lot of cases do get RFEs, but again, if the employer answers the RFE on time, answers the RFE, ensuring that everything that USCIS is requesting is submitted to meet the burden of proof, 95% in our experience, majority of the cases always get approved. Only thing is the deadline has to be met. Proper care has to be taken that you are submitting all the documents back to USCIS. That is the main thing. So the main thing to note is the deadline. What we typically say is people procrastinate until the last minute, and at last minute they find that they're not able to provide some documents. A typical example is like, for example, a work experience letter. If they wait till the last minute, they realize that their employer is not, the prior employer is not getting their experience letter on time. So don't procrastinate until the last minute. Start on day one and try to get all the documents well ahead of the deadline. Because sometimes there is a lot of things that need to fall in place. You might have to go get an expert opinion, go get an evaluation done outside. So there are a lot of things in the play, and most of the RFEs are very simple. In the H1B world, there are only a certain kind of things that they can ask. They can ask about the position, they can ask about the beneficiary's qualifications, they can ask about the company, they can ask about the bona fide nature of the job, and sometimes about the status of the maintenance of status. So these are the
Mhm.
typical things. I mean, on a high level, you can actually count on your fingers the kind of RFEs that you get for H1B, the most common RFEs. So most of the time, it is nothing very very hard. Most of the time, it is very easy. Uh, Only thing is, it's the deadline. And my our the way we do things is sometimes the RFEs are like a couple of pages, sometimes 8, 9, 10 pages. But if you summarize it to what exactly USCIS is looking for, it is always like very, very simple kind of information. So what we typically do is we always summarize, we let the employers know this is what we require. And most of the time, 99% of the time, we never see a challenge because for H1B, most of the time, because the employers are employers who are genuinely requiring these employees, and employees are 99% of the time very, very highly qualified. The
Mhm.
RFAs are never a challenge. It's more about meeting the deadline, making sure that we are not really missing anything that USS is requesting.
Yes. Right. Thank you so much for taking that up. So basically, they just need more evidence to support your document, whatever you have stated in your application. And it's not too hard. So nothing to worry about, especially if it is just an RFE. All right, Chan, thank you for taking that up. And let's move on. Let's take one more question from the audience. And this one is from Ifla. Um, why it's taking so long for F2A for spouse of green card holders?
Okay, so the F2A category, it's a family-based green card, and if somebody is a green card holder, their spouse can get a green card, and the process for that is filing an I-130 under the category F2A. So the reason, so the F2A category right now it is backlogged for a lot of countries, and you have to look at the visa bulletin. So every month the visa bulletin gets issued, and if you look under the F2A category for your country, it will tell you what is the current priority date, and most of the priority dates are very, very backlogged for F2As, and until the date is current, typically they don't speed up things. And because a lot of the countries are backlogged, they're retrogressed, the dates are back, the dates are not current yet. That is why it is taking a very long time. And the legal technical reason for that is there is a limit on the number of green cards that can be issued under F2A. There is a quota, and that quota for some countries it is backlogged. For example, for India, there is a lot of demand for F2A from Indian nationals, because there are a lot of Indian green card holders. So they're only eligible for 7% of the current quota. There are country quotas.
Mhm.
The minute you hit that quota, they have to retrogress their dates. They have to put them back. So because of these technical issues, where there is this limit on the number of green cards that can be awarded under F2A, number one. Number two, the country quota, the 7% country quota. Because of these reasons, they cannot issue the green cards. So what they do is they just wait until the date gets current, which is why you're seeing this huge delay.
Okay, and actually, there is a follow-up from IFLA, who's asking, do we expect any faster approvals for F2A for spouse?
If the date is current, you can expect an approval quickly. If the date is not current, you pretty much have to wait. They cannot issue a green card or they cannot send it to NVC for consular processing typically until the dates are current. So until if the dates are current, yes, they will speed it up. If the dates are not current, you basically the only thing we can do is monitor the visa bulletins every month. It gets released every month. Look at the visa bulletin and see if your date is current. If your date is current, what you can do is you can write a letter to USCIS, letting them know that your date is current and you want their help to take an action. And normally they look at it themselves. The whole challenge is getting the dates to be current. So your best bet is monitoring the visa bulletin every month and notify USCIS the minute you see the dates are current.
Okay. All right, Ifla. I mean, it's always good to hope for the best, so why not? You can always expect faster approvals. Okay. All right, then let's move ahead with more questions. We will take them up. Keep dropping in your questions, folks. I will take them up shortly. But before that, let's discuss. What are the common reasons for rejection of H1B applications, and how can applicants mitigate these risks? Chan.
Sure. So again, the recent experiences in the last few years, we're not really seeing a lot of denials. A lot of H1B, majority of the H1Bs get approved. During 2017, 18, 19, during that time period, we did see a lot of denials because back then they were asking for client letters. They were asking for availability of specialty occupation work for the entire 3 years. They were asking for the contractual chains for everybody involved. The burden of proof was a lot higher. And back then, they're also talking about some owned codes not being specialty occupations. For example, back in 2017, 18, 19, we had a lot of challenges with computer programmers' occupation. So back then things were different. But in the recent past, in the last 1 2 years, I think ever since COVID, we had a lot of shortages for specialty occupation workers in US. There is a lot of demand for technology employees. So what we're seeing recently is the approval rate is very high. The denial rate is very low. That being said, some cases do get denied, and the most common reason that we see nowadays is to do with the beneficiaries' qualifications. So in H1B, the very important thing is the company should be a legitimate company with a bona fide offer, and the next one is the employee has to be qualified. Majority of the time the companies are typically qualified. The reason is, if they're not qualified, they're not going to spend a lot of money. H1B is a very expensive process. So if the company is spending thousands of dollars in filing fees, paying to the US government, so the company part, typically we don't see challenges. The challenges that we see are typically to do with the beneficiaries qualifications. For example, you're applying for a IT job, and in the H1B world, you have to have a degree in a relevant field. And a relevant field is a bachelor's degree in computer science, information technology, or something related. And the challenges we have is when somebody has like a 3 year degree from India, a BCom degree, a BA degree, a BSc degree, or completely a non relevant degree, a civil engineering degree, or sometimes maybe an MBA degree, but they're trying to work as a software developer. So when the degree is not relevant to the job, because according to the industry standards, IT specialized IT job requires a bachelor's degree in a computer related field, a computer field or something related, but not in an unrelated field. So anytime we see an unrelated degree, because we do have a lot of people who have backgrounds in mechanical engineering, civil engineering, 3 year degrees, they're also getting filed for H1Bs. So those are the cases that we typically see a lot of RFEs, and we see a lot of challenge. That being said, there is a rule in USCIS for H1B where they say that you can use work experience, you can combine it with your education, and then together you can qualify. So what we do is we try to get those work experience letters. We try to get their degree, even if it is not relevant, and we have to go to a US professor and we have to get an evaluation done. And based on that evaluation, the H1Bs will get approved. The challenge that we see is sometimes some employees don't really have great experience letters. They might have experience, but they're not able to document their real experience. Uh, that becomes a challenge, because for USCIS, it's all about evidence. It is not about going back and claiming that I have 10 years of experience. It is showing the proof that you really have that experience and what did you actually do during those 10 years. So they have a specific requirement. You really have to show the job duties, you really have to show the title, you have to show the length, the duration of employment. So there is a certain way of proving things to USCIS. And the challenge we see is back in some countries, back in India, a lot of employers don't give proper experience letters. They don't put the experience, they don't put the duties. So they don't really put it in the format that USCIS wants. Those are the common challenges that we see. And if somebody is not really able to prove their experience, they're not able to prove the kind of duties they've done in their past, we see challenges. And in recent times, those are the kind of cases that we are seeing a challenge or probably a denial. But again, it is very rare. It is very rare that somebody is not really able to prove through prove that they don't really have that kind of experience, because most of the time, if they have experience, they will be able to prove their documents. But that is where we see challenges, because sometimes even if you send the right experience letters, USCIS, they complain about not having enough progressive experience. So in our experience in the last 1 2 years, those are the kind of cases we're really seeing a challenge. Most of the other cases, we're not really seeing much challenges.
What if, like maybe individuals are not selected in this H1B lottery, and if you could tell them, folks out there who are hopeful, what alternative visa options are available, and or maybe what are the eligibility criteria as well?
Sure. So for the people who are not selected in the lottery, there are two kinds that we are seeing. One, they're already in US, maybe on student visa or H4 or L1, some other visa. They're already in US. They did not get selected in the lottery. Then we also have some folks who are out of the country, maybe in India. So their H1B registration got filed. They're in India. they did not get selected. For the folks out in India or abroad who did not get selected, if they want to come to US either to study or to work, typically they're allowed to pursue other options. For example, L1. L1 is a good option. So for many folks that don't get selected in the lottery, if they're working in India, and for example TCS, they have an office, they're working in TCS India, and TCS has a valid assignment in US. So a lot of companies also pursue L1 option. There is something called L1 visa. So what that visa option does is somebody is working abroad, and if that company also has a branch in US, they can transfer them. They can do an intra-company transfer to US on something called L1 visa. So a lot of people do explore the L1 option. The challenge is you need to have an office in India or abroad and also in US. You have to meet the criteria for L1. But again, that's an option many use. And sometimes some people also use time to upgrade their academics, maybe do a master's degree, maybe get more skills through education. So they can also explore F1 options. So if they're not selected in the lottery, their F1 should not be rejected. Their F1 is independent. So the people out there, out of the country, they can pursue L1 or F1. And then we have the other set of folks who are already in US. So they might be in H4 status. So if somebody is in H4 status, they can probably pursue H4 EAD if their husband already has an I-140. So for H4 folks, we suggest to explore H4 EAD if it's an option. And a lot of folks are on F1. So a lot of students who are on F1 visa, they do not get selections in the lottery. And this is what we typically see. We see some folks exploring the Canada immigration because I see a lot of interest for Canadian immigration. I don't know much about Canadian immigration. I don't know much about the options in Canada, but at least I've seen a few folks explore the Canadian immigration option if that is what they're wanting to do, want to immigrate to Canada or work in Canada and so on. I don't have much experience, but I've seen people do that, so I just want to put it out there. And then I also see a lot of students. So students, again, they're of two kinds. Some students have their OPT and STEM OPT valid for a long time, maybe another 1 year or 2 years. Those guys don't have any problem. They can continue to stay in the country on their OPT or STEM OPT, continue, and again try their chance next year. Hopefully they find a good employer next year again. Their employer again sponsors them, and they just have to wait until next year, and they can stay in the country on their OPT or STEM OPT. They can continue to do basically whatever is required out of their F1. They can continue to maintain that status. Then we also have some students who have exhausted all options. Their OPT is expired or about to expire. There's their OPT status or STEM OPT status. Those are the kind of folks who really have to make a decision, because if their OPT is expiring or about to expire, and their H1B is not selected in the lottery, what that means is once their OPT expires, there is something called grace period. There is a 60-day grace period for all F1 students. So the minute F1 status expires, within 60 days, they have to depart USA. So if they want to stay back in USA, they are allowed to convert to some other valid immigration status. And when I say valid immigration status, they can continue their F1 studies. If they want to continue their F1 studies, they have to enroll in college. They have to make sure they study. And if their college requires CPT, CPT is mandatory, they might be allowed to pursue CPT. But before pursuing CPT, it is very important that they understand that CPT has many restrictions. They also have to check with the school. They also have to ensure that school requires CPT program, that school is letting them work on CPT. So if for anybody that is wanting to explore the CPT option, yes, it is available, but definitely do a little bit more research, talk to the school, make sure CPT is a valid and a mandatory and an integral part of whatever program they're going to study in the school. Okay, so extending their F1 status can be done. You have to work with your school, make sure you talk to your school DSO and extend it before your service gets terminated. So that is the most important thing for F1 students whose status is about to expire. If their status is not expiring anytime soon, they are fine. But again, there are a lot of folks whose F1 will expire, so they have to take some action before their F1 expires. So overall, these are the kind of things that people can do as options in case they're not selected in the lottery.
So, friends out there, you have a lot of options. So, you can still have your American dream and stay hopeful, I would say. There's so many options, as Chant mentioned. And I'm sure you have some more questions to even Chant directly. Maybe some of you are not posting here, or if you are, even, you can even ask Chant directly. You can contact him in his email address and his phone number. And of course, I forgot to mention Twitter viewers out there initially also. Thank you so much for joining us. I mean, Facebook, LinkedIn, YouTube, and Twitter as well. Folks out there, thank you so much for joining. So, Chan's email address and phone number is on the screen. Note them down. Law at spblawfirm.com. And you can even call him at the number, contact him 817 523 8247. And don't forget to check him out in his website, spblawfirm.com. Chand Parvathaneni for you, friends. And Chand, I mean, thank you so much for setting the stage for today's discussion on fire so far, half an hour down. And I'm really excited to dive deeper into the topic. So, to all our viewers out there and Chand as well, thank you. And stay tuned because we are definitely going to uncover more about the H1B application insights on yes, Immigration and Jobs Talk Show with me, Nipasa Pradhan.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
And we're back. Thank you so much, folks out there, for sticking with us. And today, in today's webinar, we have none other than Chand Parvathaneni on Immigration and Jobs Talk Show with me, Nipasa Pradhan. And welcome back, Chand, as well. You know, let's pick up where we left off before the break and let's uncover the H1B application inside. So, Chand, what else would you like to say? And there's also, you know, something like employees taking advantage of employers. Is it like a waste of USCIS fee? Or, you know, if all employers say file five, so what do you have to say about that?
So I think what you're saying is if some employee has multiple offers, because some people always have multiple offers, genuine offers. We're talking about genuine multiple offers. Say somebody gets a job offer from Microsoft, somebody gets a job offer from Google and Twitter, and so this year what's going to happen is in the beneficiary centric process, if that beneficiary gets selected, all the employers who filed the registration on this person's behalf, they will be allowed to file a H1B petition. So what that means is Google can file, Twitter can file, and Microsoft can file if they are their employers who made him an offer. So, so we have this question because what if the employee did not tell the employer, and employer is pursuing their own H1? So legally, it is okay for all the three employers to file the H1 because the three employers are independent. The three employers have a bona fide job offer. Employee is qualified. So legally, there is nothing wrong in these three independent employers filing the case, and each employer has to pay the fees to USCIS. So theoretically, USCIS is getting the fees from all these employers for the same employee because each of them have to pay the fee independently. In a way, I mean, so my thing is probably it is not ethical because the employee is not telling the employer, but legally, the employers, because they're independent and have a bona fide job offer, they're allowed to file. So you can see that as a waste of money from an employer perspective because end of the day, before October 1st or before the H1B starts, the employer has to make a decision. The employee has to make a decision. So the employee at some point of time will go back to the employer and will have to tell the employer that he is not joining the employer. So what that means is at that point of time, it is too late because the employer has already wasted his money and has been thinking that this employee is going to go and join them. So that's the reason why I think it is not ethical, because somebody is wasting the employer's time. But legally, employers are okay to file petitions because they got a selection done. However, the employee has to decide before the H1B starts on which employer he wants to stick with, and then notify the other employers that they will not uh, need to continue with the offers. Okay, so what that means is employee can only start with one company, but multiple employers can file if they got selections. Okay, so that is possible, but because the employers are spending a lot of money, and not only money and a lot of time, I think it is fair that the employee makes a decision on where he wants to work and notify the employer before they actually do the filing. So that way, employer is not wasting the time, and employer is not really waiting until the last minute to find out that the employee is not really joining them.
True, that is so true. And I mean, anyway, they're only going to be counted once, whether, I mean, they are called for 5 jobs or not, right?
Right, at least in terms of fairness to the other registrants. So whoever is an employee looking to be selected in the lottery, at least because it's a beneficiary centric process, at least
Yeah.
in terms of the lottery, they're not really creating any unfairness. At least everybody is treated equal in the lottery. So just because somebody has multiple job offers, no, they're not treated with extra uh, advantage. Last year they had an advantage. This year, even if somebody has multiple offers, there is absolutely no advantage in the lottery. They are counted exactly same as everybody else because it is through the through the passport. The only difference is you might be wasting the money of the employers, because the employers,
Employees.
not suspecting that you might not join them, might waste the money and
Mhm.
might do the filing.
Right, right. Thank you for answering that. Let's move to the chats from the viewers. Okay, we have a lot of them asking. So, Chand, let's go ahead. This one is on YouTube from Nicholas Watson. After H1B conversion, my wife's Dropbox status is refused. How will embassy contact her for further steps, and will her passport be held under resolve? Is it common for a refused status change to approved?
Mm. So the big thing is the status is refused, and refused does not mean denial. So refuse. So when you see that status as refused, all it means is Department of State, the consulate. They are required to do some additional steps on their side. So all they're doing is they're doing this background checks and doing some things to finalize that visa application. So more than likely, you will see the embassy contact you in the next couple of weeks, or maybe like in a month or so. They will tell you what is required. If nothing is required, they will issue the visa. So I think that is what will happen. And then your question about passport being held. So what happens is they keep the passport, but if you really need it for travel, some urgent travel, you can always contact them. They will give it back to you. But if not, they will keep the passport, and down the line they will resolve this issue. So if you don't really require the passport immediately, just don't worry. Just expect the consulate to contact you back in the next couple of weeks. And if you think
Mhm.
it is too long, what I think you should do is you should just contact the embassy and let them know that you're waiting, and ask them if they require any other additional documents so that you can provide it. If not, at least it's always a good thing to at least stay in touch with the embassy, at least send them an email every couple of weeks. But more than likely, they will contact you back and resolve your issue.
Right. So follow up, and I think it is still not bad news. Refused is not denial. So thank you, Chance, for taking that up. And let's move ahead. This one is from Mirza Fahad. Mirza is asking, Chand, it's a pleasure watching your show. My questions got cleared before asking. Well,
Yes.
thank you. Thank
Yep.
you, Mirza. Thank you for
Thank you.
watching. Thank you for joining us. And yeah, this one is now let's move on to this next one from Ankit. I have a question on H1B address change. My H1B stamping was completed a couple of months ago. Now I might change my home address, but job and duties remain same. Do I need to amend my H1B?
So you already confirmed the job and duties, because that is the first thing I'll ask. So the job and duties are the same. And next, the only thing is the address change. If your new address, if it is within 50-mile radius of your previous work location, so look at your LCA. Your LCA will have a work location, and if your work location is your previous home and your new home, so look at the distance between these two addresses. If you are less than 50 miles, there is no need to file an amendment, because if you're more than 50 miles, if you're not within the commutable distance of the address on your LCA, you will require an amendment. But if you're in the same metro area, you're within the commutable distance of the address on your LCA, there is no need to change. There is no need to do an amendment. But what you got to do is, the minute you change your address, go to the USCIS website, type in something called AR11. AR11. It's a form for address change. Just simply fill the form online. It will take you like 5 minutes. Fill the form online, update USCIS with your new address, and that's it. You're done. There is no requirement to do an amendment if the job duties are same and your new work location, which in your case, if it is the home, if it is in the same metro area or within the commutable distance.
Okay. Thank you for answering that, Chant, for Ankit. Let's move on to this next one from Bhuvan. I was on F1 visa for about 4 years, and last year I got my H1B starting in October. Do I file taxes for 2023 as a resident or non resident?
I think this is a question for the CPA, the tax filing guys. But my view is, in October, if you've started H1B and you're not a non-resident anymore, you are a resident. My view is you should file it as a resident, and basically you should also make sure, because on F1 a lot of people don't pay Social Security and Medicare, those taxes. The minute you come on to H1B, you also have to ensure that those taxes are deducted. Okay, so I would file it as a regular tax return. Don't file it as NR. Don't file it as 1040 NR easy, the non-resident filing. Do it as a resident filing. But I can definitely talk to your the tax person. Also confirm that is what they're looking for. But my view is, the minute H1B starts, you're not a non-resident anymore. You are a resident.
Okay, thank you for clearing that, Chant. Let's go on to Gul. Gul is asking, how can individuals improve their chances for the next lottery or application cycle after a non selection?
So again, there is so everybody is treated as equal in the lottery, and the only way you can improve your chances is by having a master's degree, because there are two kinds of classifications. One, the regular cap, which is basically everybody, and then they have this master's cap, the 20,000 master's cap. So if you have a master's degree, you're increasing your chances, because you're getting into the lottery twice. Once into the master's cap, and if you're not selected in the master's cap, you again get a second chance in the lottery, which is the regular caps lottery. So theoretically, the only way to improve your chances is ensuring that you have a advanced degree, a master's degree or a higher degree. But if not, the good thing is, at least based on the new rules, the beneficiary centric process, everybody is treated the same. Last year it was different. If somebody had more offers, if somebody has multiple job offers, they had more chances in the lottery. This year, everybody is treated exactly the same. And the only difference is, if you have a master's degree, you have that master's degree, little bit of extra chance. But other than that, there is no other way where you can really improve your chance, because once you're in the lottery, everybody is treated the same.
Okay, thank you for taking that up for Gul on YouTube. Thank you, Gul. And now I got this one from Ishan, is asking, going for H1B stamping for the first time. If I get laid off when I am in India, can I transfer to B1 or B2 visa and re-enter USA?
Theoretically, yes, because theoretically, I know a lot of people who have H1B. They also have B1, B2, and sometimes they don't want to use H1B for various reasons. In your case, because you got laid off, you can't use H1B. So if you get a B1, B2 stamping done, yes, you're allowed to come here. However, the thing is, when you go for your B1, B2 stamping, you will have to disclose your employment history properly. And if you have any questions about your H1 and your time in US, you just have to make sure that you answer it correctly. Okay, so you definitely, if you are in US on H1B, you can transfer to B1 B2. The way to do it is through a form called I-539. But if you're in India and you're going for stamping, definitely you can go for B1 B2 stamping. But you might have some questions at the interview, and as long as you answer them accurately, no misrepresentations, more than likely you'll be fine.
Thank you, Chan, for taking that up. All right, let's move on to more questions from viewers out there. This one is from JBR Prasad. Hi, when will we get the H1B lottery results? It's already starting to,
So
I
the
mean, results are
employers,
almost there.
yeah. Yeah, so the results have started yesterday. They're not completed yet, but starting yesterday, employers are being notified. So if your employer goes to the USCIS website, the My USCIS website that they have access to, they should be able to see the selections. The only thing is the selections have just started yesterday and they're still ongoing. They're not completely done yet, and the selections are getting updated in the portal slowly. So by end of tomorrow evening, more than likely your employer will have the full set of selections. And once they have it, the employers typically what they do is they take time to notify their employees.
Mhm.
So more than likely, I think if you reach out to your employer by end of this weekend, they should be able to confirm. But a lot of selections have started; they're not completely done yet. So it's an ongoing process. So
Right,
by end of tomorrow evening, you can expect to have the final list out.
right. And Chan, this year they have no email notifications, right? So they have to keep checking for the update.
So sure. Even last year, there was technically no email notification. The only
Okay.
thing what will happen is once everything is done, they will get one single email from USCIS. It will
Okay.
say the lottery results are done. So they just have to log in to see the selections. So the selections, they still have to log into the website, and website is the only place where they can really confirm the selections. The only problem is only the attorneys, the company attorney, or the company has access. So the individual employees, they cannot go and check it online. They have to rely on their employer to confirm the result back to them.
Okay. All right. And once again, I mean, thank you so much. It's so overwhelming to see so many viewers out there joining us and so many questions. So keep dropping your questions. We are very happy to take them. And yes, on Twitter, YouTube, LinkedIn, on Facebook, wherever you're watching us from. All right, let's move ahead with this next one. This one is from Prashant Tiwari. Okay, we'll take this one first. Volen Lobo asking, are there any specific industries or occupations that have higher success rates in the H1B lottery?
Yes, definitely. So there are some occupations which have higher success rate, and there is a reason for that. So for the H1B world, there is something called specialty occupation. So only specialized fields are allowed under H1B. So what that means is, if that occupation requires a bachelor's degree in a very, very specific field, more than likely USCIS will issue the H1B easily. Okay, and I'll give you a difference. If you talk about software developer, it's a complex occupation, and more than likely, based on the industry standards, majority of the employees always have a bachelor's degree in computer science, information technology, or some close field. It's a very commonly accepted industry standard. Definitely, that occupation has more chances of success. Now compare it with something like management analyst. So a management analyst, it is a generic occupation according to USCIS. You have people from a wide variety of occupations becoming management analysts. You have sometimes engineers becoming management analysts. You have sometimes people with an MBA degree. An MBA is a generic degree, not a specialized, because it does not have a particular field. It's a little bit of a generic degree. Uh, a field like management analyst, even though it's a good profession, but again, USCIS sometimes tends to argue it is not a specialized field. And we also see the same thing with marketing analysts. They come back and complain and say that it is not a specialized field. So there are definitely some occupations which always have very high chance, and some occupations which always have a trigger. So always USCIS comes back and says, we don't think it's a specialty occupation. Prove it's a specialty occupation. So because the reason for that is they go to something called occupational outlook handbook. So they, for every occupation, you this is something open to public. You can go to the Occupational Outlook Handbook, look at the statistics for the occupation. If that occupation requires a specialized degree, more than likely USCIS will not have a problem. If not, you might have a problem. Okay, so definitely some occupations always have a higher success rate, and that's why the ONET code for the ONET code is basically the code for the occupation, the code that is relevant for those job duties.
Mhm.
That makes a very very important difference in whether the H1B can be approved or cannot be approved.
Okay. Thank you, Chand, for answering that. And now let's move on to this next question from the viewers out there. This one is from Prashant Tiwari. Can my company file a green card directly while I am on my on my OPT without going through the H1B route? Hmm.
Sure. Definitely, the companies can file. We have done that a lot of times. We have done a lot of the PERM filings, the I-140 filings for a lot of people who are on F1. It is completely possible. And we also had some cases where they went all the way, the PERM, I-140, including the green card. And we did the green card processing when somebody was on F1, F1 to green card directly. Yes, it can be done. That being said, there is a small caveat. F1 is a single intent visa. We talked about this earlier in the show. So a single intent visa has some restrictions. So it can be done, but there are some precautions you have to take. And there are certain things like traveling and all those things that have to be considered. So it can be done, but definitely discuss this with your company's attorney before they start the process. But again, if done right, yes, it can be done.
Okay, all the best, Prashant. Now let's take up this next one. This one is from Mol Sabal. Is the lottery results out? Well, we took this up just some time back, Amol,
Yeah,
and
yeah. They have started. They are not completely out, but they have started since yesterday, and they're slowly progressing. So by end of tomorrow evening, everything will be done more than likely. At this point of time, they're slowly starting to come out. So they're slowly getting updated, and they don't release everything at once. They slowly start updating the website,
Mhm.
and which is what is happening right now.
Okay, so keep an eye at it. Thank you, Chand and Amol. All right, so let's take up a few more before we end today's session. This one is from Wonky Junkie. My company is sponsoring me for green card in EB3 category, and if I don't get selected in in the last chance, can I stay as B1 visa and wait for green card to be approved if my company doesn't withdraw? Hmm.
And again, I think the main thing is if you are in US, the company is allowed to start the green card process. So they can do the EB3 if you qualify for EB3. They can start the process. It's a lengthy process. So, and again, there are timelines because every country is different. The reason is there are something called country quotas and priority dates that differ from country to country. Assuming your case is your country is current, your country of birth, if your dates are current, and if your company is able to do the EB3 and the 140, and at that point of time you're in the country in a legal status, the company is allowed to file I-140 and you are allowed to file the 485. It can be done, but there are a lot of things. Your attorney might have to check the dates, see what's going on, and see where you are in the process. But again, depending on how things are done, if you are in the country in a legal status and you're maintaining legal status, yes, 485 can be filed. But the big caveat for that is your date has to be current, and every country is different. Which is why your attorney normally what they do is they look at your country of birth, the country you come under, and your priority date. So there are certain things they are supposed to follow, but definitely they can start the EB3 process, and that can be done irrespective of everything else. So if you qualify for EB3, I would suggest your company to go ahead and get that process started and see where it takes you.
Okay. Wonky Junkie is still watching us, so he's saying, sorry, I forgot to mention, I'm waiting for PERM to be approved.
So if you're waiting for your perm to be approved, my guess is you already have the priority date locked, and the only thing for you to find out from your attorney is the date current. Say, for example, at some point of time, in the next couple of months, your perm is going to get approved, and that is where your attorney will tell you if your date is current. My guess is if your date is current, yes, you're good to go, and uh, B1 B2 probably is an option. But again, remember that B1 B2 can be filed only for 6 months. Disclose your reason why you want to stay back in the country. Disclose and apply for B1 B2. during this time, if your perm is approved within 6 months, your date is current, I think you'll be in good shape.
Nice. Thank you so much for taking that up for Wonky Junkie, Chand. And Chand, I hope you have a couple more minutes. I mean, we still have so many questions from viewers, if it's
Sure, sure,
fine. Okay. The
sure, sure.
Dean on Facebook is asking, do you think DOL perm will improve in the coming months?
So I've started my practice in 2011, and this is 2024. Never did I see the timeline so bad for DOL.
Mm,
Right now, it is almost 13 months. So cases that we filed last February, February of 2023, they are getting certified now. So it is almost 13 months. I've never seen perm take 13 months. It is kind of very, very bad, in a very bad shape.
crazy.
And honestly, I don't think the process will improve at least for the next few months. The reason for that is last June of 2023, they changed the perm process. They changed the way we file the perms. They used so previously we used to file in something called PLC website. They completely revamped that process. Now they are having us to do the filings in something called flag portal. Because of that, they made a lot of changes, and it's a new process. So I think that because of this new process, at least initially, they'll be very, very slow, which is what I think we are seeing. Things are slowing down. So a few months back, it was 11 months. Then it became 12 months. Now it is 13 months. So I think at least for the next 1 year, I'm a little bit skeptical. I think things will be bad. But I think over time, I think in about a year, I think things will smoothen up. They will improve drastically. The reason being, the new flag system. It's a lot more efficient. It is just that it is a new system that just started
Mhm.
last June for the filings of for the perm filings. So for this reason, I think next couple of months might be a little bit bad. I don't expect any sudden improvements. Things will improve.
It has to. It has to. Dean, let's stay hopeful, okay? All right, let's move on. Let's quickly take up more questions. And this next one is coming up on the screen. Um, this one is from Amol asking, can I take admission side by side for MS with job with H1B working visa?
Definitely. So on H1B, you're required to work, and you're required to work only from that location, doing those job duties that are defined in your LCA. So while you're maintaining your H1B status, if you want to go to school part time and get an education, there is no problem. You cannot do other jobs, but if it is only education, you're attending classes and doing it in your free time, getting a degree, it is doable. It should you should not have any issue.
Okay, thank you. Thank you for asking that. And well, Dean is saying thank you. Thank you, Dean, also for your question. And also, Wonky Chunky says thank you. Well, stay tuned with us. Of course, we have so much more coming up. And well, I think let's take this one up, which is from Girish. Girish is asking, what are potential risks or consequences of non-compliance with H1B regulations? How can I ensure I maintain my H1B status and avoid any issues while working for multiple employers or extending my stay?
So there is one mandatory thing that all employers have to do, and that is they have to give a copy of the LCA to the employees. So anybody working on H1B, very, very critical thing, you should have a copy of your LCA in your hand. So everybody, they need to ensure they get that copy from your employer. You need to open up that LCA. You need to look at your job title. You need to look at the job work location, the salary, and for you to maintain valid status, you have to make sure you are adhering to the terms of the LCA, which is you are working like you should, you're getting paid like you should, and everything in the LCA is being followed by your employer. So if you do that, you're complying with the H1B regulations. If you're working in that same metro area, doing the same job duties, getting paid like you should, you are complying with H1B regulations. If you are documenting that through your payroll are an important evidence, so paychecks, your bank statements showing that you're getting paid, so all these things, and your residence proofs, so these are proofs that you're actually maintaining status, you're complying with the H1B regulations. And pending stay, when you're filing for your future H1B petitions, USCIS routinely issues this RFE stay, and they ask you to prove that you're maintaining your all these pay statements for your previous H1B. It's an RFE that we see time to time.
Mm-hmm.
So from your perspective, the way is ensure you're getting paid, ensure your employer is doing the right thing, and if your employer is not doing the right thing, remember that you can always go to DOL. DOL is there, and you never have to feel worried about retaliation by your employer. You have rights, even as H1B employees, you have rights, and that right is ensuring that your employer pays you like they should. If they don't pay you, they make you pay for your H1B, you have rights. You can go to DOL, you can go to USCIS. As long as you're ensuring that you're doing this, you should be fine.
All right. Thank you for taking that up, Chand. And let's move on to a couple more questions. I hope you have a little more time, Chand. Is it fine?
Sure, sure. Yeah,
Okay.
sure.
This one is from Ramsey asking, I work for a private company and they said don't participate in lottery system and they can sponsor H1B any time of the year. HR said they work on it after a year. Please advise what is the best option for me. Hmm.
So my guess is if that employer is insisting that they don't participate in lottery but they can sponsor H1B at any time of the year, my guess is that is a non-exempt employer, so a cap exempt employer. So there are some employers, for example, like universities, some research organizations, where they don't really have to go through the lottery. They are cap exempt, and as a cap exempt employer, they can file the H1B petition at any point of time. So my guess is this employer is one of those employers, and so we need to know more information about the company. But again, it is true that some companies, for example, public hospitals, some universities, some research organizations, they are counted as cap exempt organizations, and they can file a H1B even without going through the lottery. So my guess is that is pretty much what has happened with this company. And you can always research. You can always look at that company's profile and see if they really qualify to be a cap exempt employer.
Okay. All right. I mean, Ramsey, if you're still here watching, maybe you could give us more information and maybe we could follow up with more clarity for you with Chand here. All right. So, Chand, there are more questions. This one is from Prashant Singh. My employer registered my profile for this year's H1B and gave me a confirmation number. Now, what is the next procedure? How will I know if my profile is picked or not picked?
So you will have to rely on your employer. So what will happen is in the next 1 2 days, ask your employer to check and see what is the status on the website. So initially, when you got your confirmation number, you should see the word submitted beside that confirmation number. That is what happened when they registered. And what will happen this week is if you got selected, that submitted status will change to something called selected. So if the status gets changed to selected, that means you're selected. But to know what has happened, you again have to go back to your employer. You have to rely on your employer. So ask your employer to check the website and let you know what the employer is seeing. And unfortunately, you cannot check it up online. You have to rely on your employer and wait for their answer.
Yes. So, beneficiaries have to rely on their employers or attorneys. So, just stay with that. Okay. Now, let's move on to Jadav asking, how does the e-filing process differ for various types of visas or immigration applications after a non-selection?
So if you're talking about a non-selection, not selected in the lottery, you cannot even e-file. So pretty much it is done. But if you're selected in the lottery, you're going to use the e-filing system. So e-filing system, I mean, it is not something very new. For example, DOL uses the PERM filing system. The LCAs are e-filings. The PERM applications, the labor applications are e-filings. So all they're saying is just use the computer to file. Don't do a paper filing. So in terms of the burden of proof, what you're trying to prove to USCIS, what you're submitting to USCIS, nothing really changes. It is just that you're not really printing pages and you're not really physically signing, FedExing the copy to USCIS, waiting for a few days to get the receipt. So all of that is changing. So they're modernizing their systems. They're following the new ways of doing things, which is the online filings. So they can do things in a more efficient manner. But in terms of what is needed to be proven to get your case approved, nothing is changing.
Okay. Okay, thank you for taking that up. And I think we'll take the last question for today from the viewers out there. This one is from Himmat or Hi Matt. I'm not sure how to pronounce. Sorry if I'm getting it wrong. But the question is, can I work if I make it through the registration of the H1B lottery? I am on an F1 visa, currently working with my post completion OPT, thinking about not filing for an extension if I get the lottery. Hmm.
I would advise you to file the STEM OPT extension, even if the employer is filing for the H1B. The reason is, again, H1B at this point of time, you don't have an approval. The employer has to file the H1B. The H1B has to be approved, and it's always good to have a backup. And if you qualify for a STEM OPT extension, I think you should file the extension. The reason is, if something were to happen to your H1B, the petition gets denied for some reason, you have a backup. That being said, if your employer files the H1B that gets approved with change of status, you really don't require the post complete the STEM OPT extension filing. Another thing you can do is, if the employer files the H1B, ask him to do it in premium. And if you get an approval, maybe at that point of time you can skip the OPT extension. But again, if you don't have an approval in hand and the approval is not confirmed yet, I would advise you to file the STEM OPT extension, just because you always need to have a backup until the other case is approved.
Okay, excellent. I mean, thank you so much for taking that up and all those questions from the viewers and me as well today, Chand. Seriously, it was such a great, informative session. Thank you once again.
Thank you, Nipasa. Thank you,
Thank
everyone.
Yes, Chand, and absolutely. So, before we go, anything you want to give an end note to the audience out there who have joined us? We had so many from everywhere. So, anything you want to say?
Sure. Sure. I think for all the folks out here, I think just who are waiting for the H1B lottery results, stay in touch with your employers, check with them. More than likely, they will not be able to get back to you before the end of this weekend. So even though the news is out there that the selections are happening, they will need some time because the selections are still happening. They're not complete yet. So more than likely, by end of this weekend, you will have a complete picture. And starting from April 1st, from an employer perspective, a lot of things are changing. The H1B fees is drastically increasing. So for the folks out here, the H1B fees for many companies, it is increasing by as much as $920. So the H1B fees for any employer that has more than 25 employees is going to be raised, and it is going to be $920 additional from April 1st. Not only that, a lot of the H1B filings, the addresses are changing. So when the employer is filing the H1B petitions, they have to be sent to new addresses starting from April 1st. So from an employer perspective, there are a lot more changes coming from April 1st. But from the employee perspective, I think not many new rule changes. But everybody, just make sure you get the copy of the LCA from your employers. Every employer has to release the copy of the LCA. It is illegal for the employers to not release the LCA copy. So this is mandatory choice that the employers have. Out here has a copy of your LCA because that is very important to ensure that you are complying with the H1B requirements. And all the best for everybody out here, for everybody that's on already on H1B. All the best with your H1B extensions, and for everybody that is selected in the lottery, all the best with your H1B filings.
Thank you, Chand. But just before we go, I mean, since you were speaking about address change, could you just briefly talk about the um, lockbox so that folks out there will have a clear picture before we leave?
Sure. This is going to impact a lot of folks who are going through the H1B amendment process, H1B extension process, or H1B transfers. So what happens is those petitions have to be still filed as paper copies. We still have to do paper filings even after April 1st. And normally what we do is we send these H1B petitions, we FedEx them to the service centers. And normally that's the practice, the standard practice. And starting from April 1st, USCIS has announced, they just announced it this week, they said that if any petition is FedExed to the service center, the USCIS service center, they will reject the package. So we have to ensure that these are sent to the USCIS log boxes. They release the addresses for the log boxes. There are a couple of log boxes, and depending on where the employer is located, we have to see the mapping, and we have to send it to the right log box. So they just released these log boxes just this week. So for everybody that is going through an amendment process or a transfer process or an extension process, they ensure that the cases are sent to the logbox, FedEx to the logbox, not really to the service center. And if they don't do that, the cases will be rejected back and sent back. So this is more for the employers. The employers have to be very cautious, and this is a very big change because this is something that is happening for the first time, and we always sent it to the service centers.
Right, right. Thank you so much for that clarity, Chand, and for that update. So, folks out there, thank you so much. And absolutely, I mean, that brings us to the end of today's episode on Immigration and Jobs Talk Show. I really want to extend this heartfelt thank you to, of course, Attorney Chand Parvathaneni, for joining us today and sharing your invaluable insights on this topic. And Chand, always, your expertise and this clear way of explaining things, truly enriches our discussion, and really grateful for your contributions. Thank you so much.
Thank you so much. Thank you all.
Thank you. Have a great day ahead, Chand. And to all you viewers out there, whether you're tuning in from Facebook, YouTube, LinkedIn, Twitter, thank you really so much today for joining us. Your engagement and support is what makes this show possible and what it is today. So also, remember, if you have any further questions on the topic that we discussed today, we can cover it in the future episodes or take them up or personally reply to your questions. So keep commenting, I would say. And thank you once again. You can also email me in my address, that is at nipa@hirightpeople.com, or call me or even WhatsApp me in this number, 408 335 6444. So thank you once again. And this is Nipasa Pradhan signing off for now on Immigration and Jobs Talk Show. Stay tuned.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.